We're unpacking this piece of trash. Everybody's heard about it. Everybody knows about the sex trafficking lawsuit against WWE, Vince McMahon et al. And we're going to take a serious look at the defensibility of this complaint. The lack of merit. The merit lacks because it's not well pled and probably against the federal rules. It's being used as a tool of creation litigation. Plus we'll discuss the lack of evidence, how the poor evidence presented here should be used to recuperate the defendants, and how investigating that evidence properly can be used to turn the tables on the plaintiff and the plaintiff's lawyers. Few attorneys have asked me to play devil's advocate on this and want to know how I break apart the evidence and give some suggestions for a defense. A lot's come out about the volatile nature of the plaintiff. As of today, there are rumors from within that Janel Grant, who in my opinion has filed the represented equivalent of a pro se aliens from outer space / Elvis is still alive lawsuit against her targets, has lied about facts in the complaint, including her never being employed prior to working for WWE. Now there's talk that she was a stripper in Florida and has lied about her age and credentials in seeking employment from WWE. She's one of these people who runs around claiming she's 20 years older or younger than she really is and is a pathological liar. There's even talk that she attempted to name Donald Trump in the lawsuit as a co-conspirator with WWE to traffic her, and that was shot down. This is the point when her attorneys should be asking themselves the question, at best, who are we working for, and at worst, what have we done? Below in the description is a link where you can download the complaint against WWE and its parent company and agents. So go and read through that and take your notes, and we'll pick up from there an analyzation and study of a potential defense strategy. Before we begin, I want to say that this video is produced on my own personal belief that Vince McMahon did not do the majority of things he's alleged to have done in the complaint that are crimes, and therefore the complaint is without merit and clears WWE and its parent company TKO, the co-defendant. I have a lot of experience in these matters. A lot of things just don't make any sense. Usually the victim in a matter like this would be a Jane Doe and her identity would be protected. It's unusual that she's so forthright about who she is, and it's strange that she has some legal training and access to all these people in the corporate office but names none of them personally in the suit. It's not plausible that in a company that large you would not have one single person willing to attach their name to the lawsuit supporting Janel Grant's claims as a witness. Let's take a look at a few media pieces. I want the students, for background purposes, to look at some of these media pieces and ask yourselves the question: why is major mainstream media portraying allegations as being determined in fact in such a strong way when they're just allegations? This is because of how the WWE and the Ultimate Fighting Championship, the parent company of WWE being UFC owners TKO, are viewed by Hollywood in the recent multi-billion-dollar intellectual property deal between WWE and Netflix. The deal done to air WWE's flagship program Monday Night Raw on Netflix benefits a lot of people in the sports entertainment world and also benefits Netflix tremendously. But it kills off a large portion of the audience that the movie studios want for themselves. Now, instead of their films being prominently attached to Netflix, arguably the #1 distribution outlet for paid by the consumer intellectual property content that there is, those properties, i.e. the films that are these movie studios' products, now take a back seat to WWE wrestling and UFC. The movie studios now also take a back seat to finance of their films by utilizing top-tier exposure on Netflix and coming in second rung for finance via financial products through Netflix on the public market. When Netflix makes new stock issuances, the production companies they carry the work of, these movie studios benefit from these stock sales, and now WWE and TKO are likely to be first in line. And let's face it, there are lots of ways these companies can raise money together that Hollywood has no ability to participate in. People gamble on the UFC. There's a huge amount of potential litigation centered around attempts to regulate the UFC, and this lawsuit may be just an early attempt to foundationalize the regulation of UFC. That potential regulation is a key part of the strategy, I'm sure, from TKO to purchase WWE, as the UFC is sport and WWE is predetermined and a show, and it's harder to place onerous regulations on WWE because it's pure entertainment. Billions of dollars are at stake in this deal, and this obscene lawsuit on its surface appears to be a true conspiracy against WWE and the UFC. I've seen this stuff before. It only takes one really driven investigator with the proper understanding of this subject to seek, qualify, and present rebuttal evidence for the defendants that rises above the prima facie standard and exposes the conspiracy. You have to consider how Hollywood views WWE and UFC in pro wrestling and the Ultimate Fighting Championship. Hollywood is centered around finance deals to produce films that result in big payoffs before the point of sale to the consumer. This was once the theaters via distributors, and now this is essentially Netflix. Your movie or your TV series, if you're a division within, say, CBS or NBC, relies heavily on Netflix promoting your product as well as selling it. Netflix is the modern day equivalent of both the movie theater, pay-per-view, and network TV rolled into one, and WWE and UFC bring advertisers into the equation in a way that Hollywood, because of the nature of its products and general structure and operation, can never do. You could put a sponsor's name on a wrestling ring or on the octagon, and it's an accepted part of the show, but you cannot prominently place, say, a McDonald's Happy Meal advertisement and advertising inside of a Hollywood movie. The audience for that hates seeing that stuff, and it conflicts with the business model and the deals with actors, writers, etc. That's a no-go. Hollywood and wrestling have been at odds over television since the first sets went into people's homes. As time evolved, Hollywood failed to replace their point of sale properly, these theaters, with an alternative way of distributing films that generated sales. Vince McMahon, on the other hand, in WWE saw the forest from the trees and started very early on to maintain in-house their own distribution network, and built and created the WWE Network, essentially a website that their fans could go to and subscribe to and have access to their content and pay premiums for new and special content. But Hollywood failed to be able to achieve this for whatever reason, allowing Netflix to emerge as the #1 platform for just that. WWE and UFC are viewed as outliers to the movie business. They're a threat and have manifested as a direct threat to Hollywood because they've developed revenue as a form of entertainment that's based on the sale of tangible goods and advertising services. They sell products that are profitable aside from the fees paid by advertisers to generate revenue. My understanding is that the wrestler CM Punk just generated the largest ever sale of merchandise in one night upon his return to the WWE of a professional wrestling intellectual property in history. That's substantial. Some wrestling related products such as t-shirts and action figures have generated hundreds of millions of dollars in sales. These WWE wrestlers and UFC fighters are real life people attached to trademark superhero characters that have exclusive contracts with these fight companies. Hollywood actors do not have this. Hollywood generates its money in true pay-to-play fashion through finance and option deals, whereby WWE and UFC generate massive sums of money to buttress the costs of production for their entertainment up front via merchandising, ticket sales, streaming revenue, and endorsements. The legal definition of motive and conspiracy from Hollywood is met, and Hollywood has a history of this professional litigation against its competitors going back to those days when TVs were first being introduced into people's homes. Now the attorneys need to understand that it only takes just one proper understanding of evidence curation necessary to turn this entire thing around. The big question I'd be asking is, who is backing Janel Grant in this? I doubt the law firm representing her would truly endeavor to litigate a federal matter of this nature, knowing it could go on for years and years without any compensation. WWE TKO, they need to rip this apart at the seams and learn about all possible conspiracies, and in my opinion, not settle this out of court. The firm representing Grant is already showing that they have a propensity to move on to other cases. I've spoken with others they are saying were victims the way Grant claims she's a victim of WWE. I think it's likely that under the stress of exposing Grant's true intentions and character, elongated litigation and economic impediment, that this firm could seek from the federal court to resign from representation of Janel Grant, but doing that in federal court is extremely frowned upon. So they're up Schitt's Creek. We did see a switch up of the board at WWE TKO Etc this past week, and I found it truly impressive that McMahon assigned Dwayne Johnson, The Rock, to the board on his way out. Hollywood should take this as a message that they're treading in unfamiliar waters now, because Dwayne Johnson is arguably the biggest celebrity actor in the world, and is or was managed by McMahon and wields tremendous influence in that world. Now we've asked the question about who is backing Grant. The next question to ask is, do you advise your client to settle the case, or do you proceed to trial? Well, I think McMahon needs to take the stand in order to save this lawsuit against collateral consequences. Students, understand, please, this is a jury trial, and in a matter like this, the jury wants to hear the defendant's side of the story. The defendant rebutting the claims against him on the stand is the show the jury has come to see. Vince McMahon discussing how he tried to help this woman, even stuff like he felt he was truly in love with her and cared for her and believed her lies and wanted to give her a better life, is important. It's also important that Vince review and rebuke any evidence that may have been fabricated against him on the stand, as is his right, most especially these text messages, because I believe they are fabrications, and that electronics forensic evidence and testimony about McMahon's character will at minimum raise doubt, if not bring forth a smoking gun of high quality rebuttal evidence in his favor. Students should hold the concept of stalking horse litigation in the back of their minds throughout this entire study of the complaint. Lawyers should refer to the dismissal attempts of People v. Sergei Alyanakov out of, I believe it was the Eastern District of New York, for case law regarding this. The defense also has to go on a media blitz as best they can. We see that traditional news still holds weight with the public in this matter and are being controlled by entities that hate McMahon and WWE and UFC. Vince needs to use his resources to film and distribute his own interviews contending these allegations, unless he knows there's a smoking gun of evidence out there making them true, which I doubt exists. And also, McMahon has released a statement about this matter, calling the complaint replete with lies. So there. McMahon's attorneys can't advise him to go on a media blitz. That would be improper for them to do, but the federal court will not shut that down, and will have to deal with the statements he makes to the media as legitimate judicial statements and/or admissions. I can't underscore enough how important it is in a matter like this for the defense to both take the stand and put this on trial before the trial itself in the court of public opinion. One of the primary goals of the defense in this matter should be to thwart attempts from others after this lawsuit to bring similar litigation. They also have to make it known to the public all the good things McMahon has done, the opportunity he's given countless performers who otherwise would be destitute and now have homes and families, as well as the millions donated by him and his wife to charities and the endeavors they've undertaken to advance everything from finding a cure for multiple sclerosis to their support of the Make-A-Wish Foundation. McMahon is a legitimate part of Americana and American culture, and I truly suspect the people backing this Janel grant are rooted in counterculture beliefs, but that's a concept, folks, whereby our culture as a nation, for good or bad, better or worse, is not conceptual, it's real. It's important for the defense to make the public aware that there exists a difference between the character McMahon portrays on TV and the man at home and the executive sitting at the boardroom desk. I know this is problematic given the nature of the WWE business model. However, McMahon is no longer a part of that business. And for everybody saying, hey, you're giving strategy to defend McMahon, not the other defendants and not the companies as defendants, now's the time those students have to understand. Defending McMahon is the key to defending the entire company against a judgment. And students have to be cognizant that a defense as McMahon's counsel should be three-pronged in strategy. 1. Tear apart the lies in the complaint and start with the lies that surface following a take-no-prisoners investigation, with the starting point of that investigation being proving up how and under what circumstances Grant met Vince McMahon, and go forward from there using computer forensic experts, originating IP addresses that disprove some or all the text messages and who sent them and where the NDA they cite came from, question the plausibility that the messages are McMahon and not somebody else writing them, and compare them to other messages that he sent. Remember, the federal rules require only that a complaint be plausible on its surface to survive dismissal, so attack the truthfulness of the complaint paragraph for paragraph. Get this matter dismissed against McMahon. 2. As McMahon was the top dog at the time this Janel grant purports these crimes occurred, show he didn't have knowledge of what co-defendant John Laurinaitis was doing or to what extent he took these escapades, and kill the MBCA violations and the Sarbanes-Oxley requirements moving forward by killing the corporate liability attached to Laurinaitis. This comes by proving that the relationship and its sexual nature between McMahon and this grant person was private and unknown to other employees. And 3. As this Janel grant was employed by a public company, it's highly likely she signed at some point or another a corporate conduct agreement. And this is essential to proving that Grant agreed not to do certain things in her employment. And they usually cover the acts she openly confesses to in the complaint, which is really prostituting herself, that she has some legal training, even if only on the job, and that she utilized company resources to commit these acts with the ulterior motive and purpose of extorting large sums of money from the company. Perhaps this lawsuit is so essentially and immediately important because of the politics that circle around it. This goes to standing via due process. Now McMahon has had his home, I believe it was, raided a while ago, and was never arrested or charged with any of the crimes alleged in this lawsuit. I won't speculate on what the FBI was looking for, because lawsuits are about facts and theories that can be proven in law, but it's worth noting that the instant suit alleges McMahon had this Janel grant sign a non-disclosure agreement, and that the agreement being signed was part of a payoff deal for a few $1 million to prevent her from discussing confidential information. Well, that confidential information was not enough to have McMahon criminally charged. So there's a presumption of innocence in the law for McMahon. That's a big staff to run with toward the courtroom. Now think about this. In matters involving rape, which is what Janel Grant is truly claiming happened to her, law enforcement, local police, FBI will usually make a preemptive arrest. They usually arrest a suspect with little or no evidence. In fact, many cases, the threshold of evidence for arrest centers solely on if the suspect admits to just having had sex with the alleged victim. The preemptive arrest did not occur in this matter, and also the FBI has announced that they're investigating the matter. Furthermore, in cases like this, It's not uncommon for the defendant, if they're truly innocent, to ask the FBI to start an investigation of the matter. One should proceed with caution when announcing publicly that they asked the FBI to investigate to support their defense, because the FBI might look at that as interference. So don't do that. All interested parties, students, lawyers, etc. should understand that this is a great study case because it's promotional. It's a clear case of the plaintiffs applying stalking horse against justice tactics to intimidate wealthy people into paying a huge settlement for acts they've extrapolated or that are outright fraudulent. And in most cases, they've participated in these acts with their own unclean hands. I've watched attorneys take on clients like this without performing proper due diligence, or in some cases zero due diligence, and it puts them out of business. Seriously, firms both big and small have gone out of business by taking on crazy clients. I've seen people like Janel show up with $50,000 cash in a duffel bag in a law office, and experienced and intelligent attorneys look at the cash and say to themselves, this will come back to haunt me. Janel is, in my opinion, for all of you young, wet behind the ears future Thurgood Marshals salivating at the paper chase and Mr. Smith Goes to Washington, just the type of client you need to run away from, like Jesse Owens running the 4-minute mile, because this woman can be the nightmare client every lawyer loses sleep over. Remember, in our society, we go to court to determine the truth, what is true, what is not true, and there's very little in between. And when your client's lying to you about pertinent facts of the complaint, you slap your affidavit on with your voucher under law saying their statements are true and correct on the basis of your own personal knowledge learned via your own due diligence, like these guys have, then you set yourself up for failure, not to mention a sanctions hearing. When pursuing litigation, you have to ensure your complaint is well pled and plausible in order to survive a Rule 12 dismissal. This complaint does not meet that standard in my view. Legal students should also break apart the complaint on the plausibility of the plaintiff's claims juxtaposed to the clear lack of being able to prove up in evidence the sex trafficking count. So young future litigators of America, beware, because this Janel is a nightmare client. And my understanding is the lawsuit's not even had a hearing yet, and I'm interested to see what the judges say about this. I prod the lawyers for the defense to attack the poor quality of the evidence pasted into the original complaint and raise the questions about the evidence to educate the judges as to the stalking horse nature of the suit, that there's no mention of triangulating cell phone tracking data at all supporting these text messages, zero computer forensics investigations findings, and some of these messages appear to be fabrications, even just in their existence as true. See paragraph 196. This is a stretch to prove if the messages even exist that are missing. This is a large part of the thrust and basis of the complaint of sex trafficking and poor legal product to simply state with emphasis and conjecture as a fact that Vince McMahon stated in a text, "I want to drive you lower and lower, so low you might beg me to sell you." And proof of this message is absent in publication within the complaint. This is the criminal standard, but I believe even the messages displayed will be proven as fabrications, and maybe I'm wrong about that, and it might be against the law in some states to engage in extramarital sex and use sex toys and have sex in a state where you're not a resident in, sure, but that does not amount to sex trafficking. All aspiring litigators should take away from this that although these type of lawsuits are considered by many to be a growth potential sector of law, at bottom they can be volatile, ticking time bombs that explode in the faces of plaintiffs' attorneys before federal judges and result in sanctions under Rule 11 for these lawyers, including losing their license to practice. If you ask me, the plaintiff is being put up to this, and her lawyers are equally pawns in this game, and I believe this is a setup job from Hollywood with ulterior motives and secret players guiding the plaintiff. This thing's meant to extract information to build on a future series of lawsuits that will be based on this matter's factual findings. Those factual findings will be seemingly benign at first, but cumulatively will aid in coloring a claim that the public traded companies under defense have created what's called a rape culture environment. And that's a fairly new style civil claim. It's attached to negligence and falls in violation of the Model Business Conduct Act, Sarbanes-Oxley, and the laws of authority, but lots of judges have rejected the creation of a rape culture environment where you cannot prove that the defendants had full knowledge and intent to create that environment. And this is a really defendable complaint. Now, after about a week since this hit the docket, a lot's transpired, and I've had some time to consider what my strategy would be in investigation and defense. We will get into the recent happenings that qualify as judicial admissions and how those both help and hurt the parties. I want to say this is a fishing expedition, and a volatile one at that, because the best remedy for the defendants rests on their lawyers truly laying the smack down, no pun intended, with a hard, swift as possible move to dismiss the suit. That would come by attacking the value of the pleadings. In other words, how well pled the complaint is, and the intent of the lawyers in filing this complaint can't be to actually win with the complaint itself. I just can't see that. Now, this lawsuit is both volatile and important because it's not easily dismissible, and the option of Rule 12 dismissal, because it's poorly pled, folks, because it lacks evidence rising above the prima facie standard in support of the claims. It does give dates and some specifics and reads more like a wrongful termination suit, sans any itemization of damages and a dollar figure in relief, but it's still hard to get it dismissed as undefendable. Now, here's the cog in the defense machine. This matter is about establishing facts to base future lawsuits on. Mainly that McMahon knew and allowed for co-defendant Janel to act in deviance against women on the job. Investigations were made, and Laurinaitis was fired and rehired and subsequently fired again, I believe. And these terminations are being done because they're required. Now, pursuant to the most recent termination of Laurinaitis, he has released a statement that he too is a victim of McMahon's acts. Well, we have defendants now working against each other, and that occurs when one is innocent and the other is guilty. Laurinaitis is hurting his own defense with statements like that. Students, if you're the attorney representing McMahon or WWE or TKO in this matter, you have to remain cognizant that this matter is about corporate authority, laws, and specifically as they relate to the MBCA, the Model Business Conduct Act, and accounting laws. I put a few videos out about this, and it's most pertinent in defense here to understand that these statutes require the corporate entity to first investigate without bias the claims that violate Sarbanes-Oxley and other laws concerning publicly traded companies. And that has occurred. And the defendants, McMahon and Laurinaitis, are no longer employed or participate in any way with WWE TKO. Now that Sarbox is off the table, and other acts and statutes fall off the table, potential servings to the legal plate, now is the time to protect the company from the MBCA violations, and this goes to the definition of what is an agent of the company. If I were defending the company here, I'd color the contentions against sex trafficking in a few ways. First, I'd color it with statements that flush out the ability of the plaintiff's lawyers to determine facts about the MBCA by showing that WWE and TKO took reasonable measures to eliminate the dangers alleged in the complaint, and leave it at that. They terminated Laurinaitis and removed McMahon fully. Remember, TKO just acquired WWE, like a few weeks ago? I would also zero in on the preposterous nature of the complaint against McMahon, and how it's difficult to answer the complaint per Rule 12, and cite that the evidence presented by the plaintiff is either false or cannot be qualified. The answer comes before the discovery phase. I would proffer that, rare as it is, a complaint is so poorly construed as to be impossible to contend. This complaint arguably meets that standard for the corporations that are defendants. At least it gives standing in answer, and maybe an answer has been filed and I'm unaware of it, but the defendant corporations can seek leave for amended answers and countersuits, and that has to be done. The countersuit seeking injunctive and declaratory relief has to be filed against this Janel grant if it hasn't been filed already. So now you've embarked on your defense in a truly vigorous way and put the plaintiffs on trial in the court of public opinion before the trial itself, because you have a billionaire client who's intelligent and has tremendous media resources, and he's making public appearances and defending himself and the company he built against a person some media outlets are starting to say is mentally ill. He's discussing how he had sympathy for this Janel girl, how he tried to help her, or maybe he's saying things in the media like, look, she's a hooker, I paid her for sex and we became close and I tried to do business with her, but your client is out there doing this now and you have to kick ass and take names in the courtroom. Shaping the question is the first power to shape the decision. First, we need to look at the elements of law. You need to read the law. Let's start with count 1, 42 U.S.C. 19401. The act to remove enforceability of the non-disclosure agreement, a fairly new addition to Title 42. And here I'd say that Grant obviously has some legal training or experience because she worked in the legal department at WWE, and the relief requested under this law seeks to allow her to make statements about events and circumstances she is already openly discussing, and some, if not all of which, she's alleging in the lawsuit. She negotiated the terms of the NDA she alleges exists, but did not exhibit the NDA as evidence, which is perfectly docketable had she done it. There's a question as to whether or not she has a copy of the NDA herself, and also it may be best for the defendants to publish the NDA depending upon what its content is. This is a recital of a moot part of the lawsuit meant solely for the purpose of protecting this Janel girl so they can't stop paying her for whatever it is she claims she saw happen or experienced at WWE that afforded her the settlement out of court she received over $1 million for, and now claims the company is not paying her. She wants her cake and wants to eat it too. Meanwhile, she entered into a legally binding agreement via the NDA that if, as is likely, she never gets $1 from this lawsuit, will now be held up by the defendants as legitimate legal cause not to pay her another penny because she breached the agreement with this lawsuit. Count 2 is essentially the same thing as count 1. It asks the court to find under common law that the NDA is unenforceable. Look, any breach of the contract or implied contract makes this agreement unenforceable as far as this discussion goes for both parties, and so do Fruit of the Crimes Acts. There's no right of privacy in the discussion of alleged criminal activities. Again, this is a back-end attempt to protect this Janel grant from losing the additional $2 million she appears to have some sort of claim to being owed by either WWE or McMahon personally. This is starting to look like a preemptive legal strike should McMahon and his wife get divorced, and that's a totally separate deal from this defense. So let's get off of the speculations and let's focus on the count. All the declaratory relief requests about the NDA should actually be later counts. It's preposterous to think that these lawyers are arguing for declaratory relief over the enforceability of an agreement before arguing for relief on the serious crimes as Janel alleges. The first 2 counts are almost an attempt to make the court complicit in protecting Janel Grant's false narrative portrayal of McMahon, and the companies are parts of the complaint that are false. And this is why I say study People v. Alienakoff concerning stalking horse litigation and the use of NDAs and other documents like it to stalk due process. It's an unnecessary recital of alleged facts and should come in as dead on arrival. Count 3 has to be defended against vigorously. This is a main focus of the defense. There's a right of private action here It can be brought this way, but right off the bat, the defense needs to educate the court and the jury, if it gets there, about the differences between McMahon's private relationship with Grant and his professional relationship with Grant, if a private relationship even existed. The count is somewhat lacking because it mentions that McMahon traveled the globe for business unrelated to this Janel person. There's no substantial showing that any of this travel had anything to do with profiting off of Janel Grant as a sexual prostitute, and there's substantial evidence that Grant consented to the sexual activity she claims she's a victim of and participated in the crimes she alleges she's a victim of, their construction, their implementation, and their cover-up via the NDA. She has unclean hands in this. If you take what she says to be true, another important element of this is if anybody is criminally charged in this matter, the civil action is suspended until that matter is resolved. Let's see if this John Laurinaitis guy is arrested. But this all speaks to the setup aspect and ulterior motives of the attorneys in Grant in filing this lawsuit, and I think on the basis of suspension of civil litigation, that it's a fully legitimate thing for the FBI and private investigators to seek evidence that Janel Grant was paid off to bring this lawsuit on behalf of people conspiring against the companies in McMahon. My gut tells me John Laurinaitis threw himself under the bus in this thing for whatever that's worth. But this is where the defense needs to file a Rule 11 hearing against the lawyers for this Janel Grant. Imagine impaneling a jury in a federal case and Laurinaitis gets arrested and now the action's suspended. What do you do with the jury? Do you sequester them while another trial proceeds? Do you mistry the case and waste all these resources? What a mess these lawyers have created. This is why these suits usually come after a criminal trial, not in reverse. I don't think Count 4 shows with any merit or plausible belief that plaintiff has presented facts substantial to prove that all claims in the complaint can be reasonably construed as legitimate. She has to color all claims as plausible via well-pled arguments in order to survive dismissals and motions. So, like Count 3, this count should be argued in the same failure to prove the elements of law. Count 5 is another endeavor into the abyss because there's no evidence to support enforcement of the claim. Count 6 are battery laws. I have not seen the mention of a rape kit. McMahon was never charged with crimes. Yes, civil battery is a private enforceable right, but you have to prove it, and the complaint needs to survive dismissal, which I don't think this complaint was ever meant to do. This is at best extortion of a giant corporation, and at the worst a conspiracy by McMahon's enemies and competitors to imprison him for their own financial and other gains. Count 7, more civil liberty battery claims that are akin to a group of teenagers entering a bodega with shotguns and robbing the store, and then the girl says she's forced to rob the store, forced to train using the firearm, and forced to go into the store and shoot the owner and drive the getaway vehicle, and now she's all of a sudden a victim too. This Janel is more of a perpetrator in all of this, in my opinion, than anything else. Count 8, about intentional infliction of emotional distress, is something that you bring with good faith in standing after a criminal trial is over. But that's not what these lawyers want, because that would stop their case. This count asks for a finding of fact spaciously and makes me question the plaintiff's lawyer's ability to litigate this matter. Possibly McMahon's attorneys could make a showing that he's the victim of emotional distress from Grant. She was very manipulative and managed to obtain a position in his company to get him to lavish her with a fortune in gifts, according to her. Yeah, this is just a bunch of drama from the plaintiff, and according to her, McMahon tried to secure help for her with her doctors as relates to her physical and emotional traumas and what she perceives to be physical or emotional traumas, some of which she admits predate her relationships with McMahon and WWE. Remember, defenders have to be cognizant in separating the personal and professional relationship between the two, and also between Grant and the corporations. There has to be a separation. Unless Grant had a partnership agreement with McMahon, the trafficking allegations and all their subsidiaries should go out the window. count 9 is just as misplaced when weighted against the allegations and other counts. So, here is where students and pundits need to begin their legal analysis. You put McMahon on the stand if this matter gets to that point. With that said, you need to go to your client if it's McMahon and tell him, number 1, he needs to prepare to be arrested, and number 2, this is gut check time. This is when you can't fear what's going to happen with your wife, your family. You need to get missile lock focus on getting your side of the story out there before the government throws you into a cell. And it has to be the truth. If you did or did not have sex with this woman, you need to confess that in the media. If you sent those text messages displayed, you need to own up to them or make aggressively your case that they're fraudulent. Furthermore, even if McMahon's people got the FBI on board, while that may be a good thing in a lot of respects, they can't rely on the FBI to truly do their job for them in the investigative process. They need to unpack the compressed data from Vince's cell phones to track the IP addresses, even if they're blind IP addresses from all communication between the two. And I find it highly suspicious that among these questionable as legitimate text messages displayed in the complaint, one of them features Janel Grant saying she no longer has a phone that contained the pictures and other data that would prove up her allegations. As sad as it may sound, this case is highly politicized, and it raises a big picture constitutional question about due process, which is a nightmare to litigate, but something that defendant McMahon should start talking about right away. Constitutional rights. McMahon should be reading the federal rules of evidence and participating in his own defense strategy. If you're the defense attorney here, you need to listen to a guy like Vince McMahon, as in these cases, the defendants know best how to defend themselves. You have to try this type of civil matter like as a criminal case, really. And you also have to keep your ear to the street and make moves in the street to prove up your case and flush out the other side's defenses to your contentions. Now, speaking about keeping your ear to the street, private investigators should not just be doing the computer forensics. Vince's attorneys should be coordinating a war room and installing those investigators in it, and this should be done by right in a foreign country. This is how you defend this type of case. The private investigation needs to be centered outside of the federal jurisdiction. Of course, you share all the pertinent findings with the government, but you need to maintain that data in your possession. This is how it goes. The focus of the investigation has to be on this Janel Grant and her lawyers. First on Grant, and what comes up you use against the attorneys who are required to perform due diligence. Big picture constitutional rights. This matter is so trendy because it involves the very current dilemma of our justice system and courts being so overwhelmed by what can only be described as a large portion of our economy called the litigation creation economy. In other words, industries that are based around making money from litigation. The majority of deals done in Hollywood are based around potential lawsuit revenues, and lawsuits like this are used as harassment and as a threat that if you don't pay the plaintiff off, you could go to jail regardless of guilt or innocence. This is the worst type of litigation. I'm not saying these allegations are factually untrue, but I am saying I believe they are mostly nonsense and untrue, and put to the test this theory that if enough people in our country don't like you and want to see you in prison, that this can be done through a series of preemptive legal strikes. That's the dilemma we're facing. Our country is a republic. The law is supposed to be interpreted via the merits of each individual case and not the opinion of a majority. And I find it alarming that a lot of these media pundits have jumped on the slander bandwagon and portrayed in some cases the allegations, they're only allegations, against defendant Vince McMahon as factual. His attorneys should be filing lawsuits against these media outlets for allowing their agents to air damaging false narrative statements against McMahon, accusing him even of being evil, and outright proclaiming the allegations as factual. This is strategic to do this. It's not emotional justice. It's a tactic of strategy and helps to defend the McMahon family. At bottom, my opinion is Vince McMahon has been through the ringer as a defendant in civil lawsuits, as a defendant in a criminal indictment. He has stood up to allegations of sexual misconduct in the past from employees within his organization. He's overcome and in many cases defeated these allegations against him and WWE in the past. And I don't believe that he could ever be so unintelligent as to behave in the way he is portrayed in this lawsuit. I think that a comparison of the very weak evidence presented against him juxtaposed to testimony, statements, and samples of his style of writing and its prose will also help to prove that these text messages are in fact fabrications. I hope there's no truth to this. I'm a big fan of McMahon's. I'm a big fan of his family and the company that he built. A classic matter for study of strategy. So good luck in strategizing Janel Grant versus WWE TKO McMahon and Laurinaitis, and I look forward to hearing from you regarding this video and regarding what you're doing to build a defense for the company, because this is just an excellent case that will allow a defendant's counsel to pull out all the stops and go the distance, as they say.